Hello, my name is Crystal Dahl, and I am the Online Communications Specialist here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, Controlling Where to Fight and Who Pays for It, a discussion of recent developments in Delaware forum selection and fee-shifting bylaws and Delaware's new arbitration option. I have the great pleasure of introducing today's three speakers. Steve, Vanessa, and Sarah all come from our Wilmington, Delaware Meritas affiliate Bayard. Steve's practice focuses on corporate, commercial, and intellectual property litigation as lead trial counsel. He has tried cases involving fiduciary duty claims, control disputes, advancement, indemnification, breach of contract, antitrust, securities, patent infringement, copyright infringement, and trademark matters. Steve also counsels clients concerning the general corporation law of the state of Delaware and Delaware's alternative entity statuses. Vanessa is an associate focusing her practice in the areas of corporate governance and commercial litigation in the Delaware Court of Chancery and the Delaware Superior Court, and intellectual property in the District Court for the District of Delaware. She has experience assisting clients with breach of fiduciary duty claims, business divorces, control disputes, breach of contract cases, advancement and indemnification, and books and records requests. Sarah is also an associate practice in the areas of corporate and commercial litigation, handling corporate, contractual, and intellectual property disputes in Delaware's state and federal courts. Before we get started, I would like to quickly go over a few housekeeping items. Meritas now offers the ability to listen to our webinars through your computer speakers. If at any time you have any difficulty hearing the presentation, you may call into the associated telephone line instead. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with the support team. If you have any questions, you are also welcome to use the chat feature found on the left-hand side of your screen. Questions will be answered throughout the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of this webinar, as well as the presenter's contact details. You're welcome to reach out to them if you have any questions after the webinar. With that, Steve, are you ready to get started?
I am. Thank you, Crystal. Good afternoon, everybody, and thank you for joining us. You should see on your screen now is a brief outline of what we're going to talk about today. I'm going to first talk about forum selection bylaws. We're going to walk through where they came from, what they are, some recent developments here in Delaware, and then proposed legislation regarding them. Then Vanessa is going to talk about fee-shifting bylaws, again, what they are, what is permitted under the Delaware General Corporation Law, which we refer to as the DGCL, recent developments and proposed legislation. And then Sarah will talk about the recently enacted Delaware Rapid Arbitration Act. She'll talk about what it is, where it came from, and why we use it, and why you should consider it for your clients. If at any time I think we can see questions, so if you have questions at any time while we're talking, and we'll do our best to answer them. So Delaware takes a three-pronged approach to forum selection bylaws. And as you can see on the screen, that focuses on allowing Delaware corporations and those who form them and invest in them to establish their own governance rules. Delaware tries to provide a strong judiciary to ensure the fair and even-handed enforcement of those rules, and then to provide a clear statutory structural framework. Before we go further, I'm going to pose a question to myself, and that is, why should we care about forum selection bylaws, and where did they come from? We should care about forum selection bylaws because they determine where shareholders can raise disputes relating to the governance of the corporation. Generally, the recent push for forum selection bylaws, although they are by no means a new creature, come from the problem of multi-forum litigation. Multi-forum litigation generally deals with the fact that now, and I don't have the exact numbers, but somewhere north of 94% of all publicly announced transactions are challenged in some jurisdiction or another. Without commenting on whether whether multi-forum jurisdiction is good or bad, what usually happens after a deal is publicly announced is shareholder strike suits are filed in a number of different jurisdictions. There's often a race both between jurisdictions and between lead plaintiffs and their counsel within certain jurisdictions to gain control of the litigation. That's in part driven by fees. That's in part driven by a desire to control how the litigation goes. Companies, though, it's expensive, and there's a lot of literature that multi-forum litigation is not good for shareholders either, because it just drives up the costs to have the same suit litigated in multiple venues. So forum selection clauses are one way that at least Delaware and practitioners are working to address this problem. What is a forum selection bylaw? A forum selection bylaw, much like a forum selection clause in a standard contract that everybody's probably more familiar with, is a bylaw provision that gives exclusive jurisdiction to a particular locale, state generally, for the litigation of various subsets of disputes. We've put on the screen here the sample bylaw, or rather not a sample bylaw. This is an actual bylaw that was featured in the Boilermakers vs. Chevron case that we'll refer to as Chevron and discuss a little bit later. Before we move on, I think it's important to consider, and a lot of the debate and discussions about forum selection bylaws are focus on how these bylaws are adopted. There are three ways generally that forum selection bylaws can be adopted. First is through an initial public offering. They can be included in the corporate governance materials that are sent out to shareholders or prospective shareholders or the market in connection with an IPO. The second way is through a shareholder adopted bylaw, although that is largely not how these particular bylaws are getting adopted, but shareholders under Delaware law at least retain the ability to adopt bylaws and certainly have the right to adopt a forum selection bylaw. And then the third way, and this is perhaps the most controversial, is through directed bylaw amendments. The reason why that's potentially controversial is much like there is literature and scholarly acknowledgement that multiplicities of the same suits in different jurisdictions is expensive, there's literature on the other side that supports the argument that restricting where shareholders can file suits sort of ties into what Vanessa will talk about, limiting who pays for those suits can silence important stockholder-driven actions that are important for the governance process. So courts, I think, will pay particular attention to director-adopted bylaws. There's also another argument to somebody challenging a director-adopted bylaw, which is you can challenge that based on the adoption, both whether the bylaw itself is invalid, which the cases we'll talk about clearly say it is not, but it could be adopted in breach of a director's fiduciary duties if that director or if those directors were causing that bylaw to be adopted to entrench themselves, for example. When directors are going to have the authority to adopt bylaws, there is a requisite charter provision. So just take note of that for those of you on the transactional side who draft these documents, that if you want, under Delaware law, to give directors the authority to adopt their own bylaws, that a charter provision is necessary. There were two recent cases we're going to talk about The first, as I mentioned, is Boilermakers v. Chevron. This was actually a consolidated case of two. Chevron and FedEx both had identical bylaws. FedEx ultimately settled before the court issued its decision. This was a motion for judgment on the pleadings. This was an opinion issued by then Chancellor, now Chief Justice Leo E. Strine. And it was a question of first impression. The question was whether forum selection bylaws are facially valid. The court considered two counts of plaintiff's complaint on the motion for judgment on the pleadings. First, whether the bylaws were statutorily invalid because they exceeded the board's authority. And second, whether they were contractually invalid because they were approved only by the directors of the company, not by the stockholders. The court ultimately found that the general corporation law of the state of Delaware powers directors to adopt bylaws relating to the governance of the company. These bylaws did just that, and so they were within the statutory authority and therefore valid. The court also found that they were contractually valid. One interesting point out of the Chevron case is that an exclusive bylaw or a forum selection bylaw setting Delaware as the exclusive forum is likely to be enforced, if anywhere, in a non-Delaware court. And what Chancellor Strine wrote in explaining why he was deciding the Chevron case in the procedural posture that he did is interesting. He wrote, "A foreign court that respects the internal affairs doctrine, as it must, faced with a motion to enforce the bylaws, will consider, as a first-order issue, whether the bylaws are valid under the chartering jurisdiction's domestic law." In other words, Chancellor Strine, now Chief Justice Strine, basically said to all of Delaware's sister courts, if you guys are doing your job, you need to enforce these bylaws. That, I think, was in direct response to cases in other states, particularly California, that did not defer to Delaware on issues of corporate governance, and it's just an interesting interplay. It's important to note, and we'll talk about this a little later, that forum selection bylaws are limited to a narrow, or at least have only been held valid as they focus on a limited number of bylaws. The second case I wanted to talk about is the City of Providence versus First Citizens Bank Share. This, too, was a decision at the pleading stage, and this was the reverse of Chevron. Here, First Citizens Bank Shares adopted a bylaw that selected North Carolina as the exclusive forum for intra-corporate disputes. The court found that, like in Chevron and for the same reasons as in Chevron, the forum selection clause was valid under Delaware law. Interestingly enough, at least for Delaware lawyers, the Chancellor included a footnote that said he wasn't opining on the wisdom of choosing North Carolina as the exclusive venue, only that the general corporation law of the state of Delaware did not prohibit the company's selection of that. In dicta, the court noted that the facial validity of the bylaw depends somewhat on the rationality of selecting which state is the exclusive, in which state exclusive jurisdiction will lie. Here, First Citizens Bank Shares was a Delaware corporation with its principal place of business and most of its operations in North Carolina. So the court didn't have any problem with the selection of North Carolina as the venue for the forum selection clause. The court suggested or implied that a different result might follow if a irrationally chosen jurisdiction were selected. So, for example, if a Delaware company operating in New York had an exclusive forum selection bylaw for Alaska to make it more difficult for shareholder plaintiffs to bring suits, such a forum selection bylaw may not survive. Another thing to consider, especially for those transactional folks who may draft or advise companies in including forum selection bylaws. The First Citizens Bankshare bylaw included a limitation that said it would only apply to the fullest extent permitted by law. That the Chancellor noted gave the bylaw additional validity in that sense. In direct response to the City of Providence, well, before I get there, sorry, I'm jumping ahead, we put together a slide which we borrowed from Claudia Allen's helpful research, which shows that after Chevron, the number of public companies that adopted forum selection bylaws has increased dramatically. So obviously, the Court of Chancery's blessing of that was viewed in the marketplace as helpful. In response to Providence, to the City of Providence case, the Delaware General Assembly has proposed and is considering legislation that expressly authorizes forum selection bylaw provisions for intra-corporate claims, but expressly prohibits any company from excluding Delaware. So in other words, what the statute, if passed, we expect it to pass, the statute, if passed, will permit companies to adopt a bylaw that chooses either Delaware or any other state, but it could not choose only another state. Of course, under this proposed legislation, they would be free to choose only Delaware.
Steve, just a quick question on while you're going through this. Could you just explain, for the benefit of us all, what intra-corporate claims are?
Sure. So as we discussed earlier, there are a limited number of cases of types of litigation that forum selection bylaws have been upheld with respect to, and those are intra-corporate claims. The proposed statute defines intra-corporate claims as those brought in the right of the corporation based upon a violation of a duty by a current or former director, officer, or stockholder acting in such capacity, or those as to which the general corporation law confers jurisdiction upon the Court of Chancery. This, in reality, breaks out into 4 types of claims. Those are derivative claims brought belonging to the company but brought by a stockholder on behalf of the company, breach of fiduciary duty claims generally, statutory claims under the general corporation law. The biggest example of that on the stockholder side would be a books and records action for directors and officers, advancement or indemnification actions. And the final category would be internal affairs suits that relate to the governance of the company. Think your voting agreement cases and the like. That brings us to the conclusion of my section of the presentation, and I'll turn it over now to Vanessa to talk to you about fee-shifting bylaws.
Thanks, Steve. So, as Steve mentioned, I will be talking about fee-shifting bylaws. So what are they? Before you on the slide is a sample fee-shifting bylaw. It's taken directly from the ATP case, which we'll discuss shortly. I won't read through the entire thing, but I would just highlight Part 2 of the bylaw, which provides that the claiming party that does not obtain a judgment on the merits that substantially achieves in substance and amount the full remedy sought is jointly and severally liable for reimbursing the corporation's attorney's fees and expenses. I know that's a little bit of a mouthful, so we'll dissect that a little bit. So what does that mean? First, fee-shifting bylaws are not bilateral loser pays provisions. The fees are only shifted to plaintiff and related parties. Second, plaintiff and related parties are automatically responsible for fees, costs, and expenses unless 2 things happen. 1, the parties reach a judgment on the merits, and 2, the judgment received substantially achieves the full remedy sought. This is concerning for a variety of reasons. First, most cases today are resolved by settlement, and therefore there is no judgment on the merits, and the plaintiff would have to pay fees. And second, the plaintiff has to win on all counts to avoid liability for fees. So a win on some counts still results in fee shifting. Advocates of fee-shifting bylaws say that these provisions are meant to deter stockholder litigation that may be frivolous and a costly distraction for the company. Opponents express concern that these types of bylaws will make stockholder litigation, even if meritorious, untenable for many stockholders. So given these concerns, I think it's helpful to go back to the DGCL and see what's permitted under its current construct.
Vanessa, before you move on, you mentioned that even if the parties reach a settlement, plaintiff stockholder may still be liable for fees. Is that correct?
Yeah, that's correct. So like I said, that's one of the main concerns of opponents of fee-shifting provisions. Namely, it would be really hard for a plaintiff to avoid having to pay fees under most of these circumstances because settlements are not a judgment on the merits, so you don't meet the exceptions to avoid the fee shifting. So turning over to what does the DGCL permit? As you can see on this slide, the Delaware General Corporation Law is very broad and gives wide authority to the board and the stockholders to adopt binding bylaws and charter provisions. Steve went through how to adopt bylaws and make those changes. So I'll just briefly go through Section 109B, which provides what's permitted in the current construct. The Section 109B provides that the bylaws may contain any provision not inconsistent with the law and with the certificate of incorporation relating to the business of the corporation, the conduct of its affairs, and its rights or powers, or the rights or powers of its stockholders, directors, officers, or employees. Under Delaware law, corporations' bylaws are presumed to be valid, and the courts will construe them in a manner consistent with the law rather than strike them down. Given the breadth of 109B, it's not surprising to learn that the Delaware Supreme Court held that fee-shifting bylaws are facially valid. I mentioned briefly before the ATP decision. So this was the first case that really dealt with this issue. ATP is a Delaware non-stock corporation that operates a global professional men's tennis store. And in 2006, the ATP board amended its bylaws and added Article 23, which provides for fee shifting. The actual fee shifting provision is the sample one that I had in the first slide in my section of the presentation. And so it requires that the claiming party obtain a judgment on the merits and that it substantially achieves in substance and amount the full remedy sought to avoid fee shifting. A year after it amended the bylaws, the ATP board voted to amend the TOR's schedule and format, and that resulted in a lawsuit by its members alleging antitrust and breach of fiduciary duty claims. The action was brought before the District Court of Delaware, which, after a 10-day trial, entered judgment on behalf of ATP and the director defendants. Not surprisingly, ATP moved for fees pursuant to Article 23, its fee-shifting bylaw, and the district court ruled that federal law preempted the enforcement of fee-shifting agreements when antitrust claims were involved. ATP appealed, and the Third Circuit found that the district court should have decided whether the fee-shifting bylaw was enforceable as a matter of law before deciding the preemption issue. So it went back to the district court, and the district court found that this was a novel issue under Delaware law and certified it to the Supreme Court of Delaware. So the Supreme Court of Delaware was asked whether and under what circumstances a fee-shifting provision in a Delaware non-stock corporation's bylaws is valid and enforceable. And the court held that fee-shifting provisions in a non-stock corporation's bylaws can be valid and enforceable under Delaware law, and they will normally be applied to all members of the non-stock corporation regardless of whether they were adopted before or after the member in question became a member. The key takeaway of this case is that fee-shifting bylaws are facially valid, but they may not be enforced if they're adopted or used for an inequitable purpose. It's more likely to be enforced if it's adopted for the appropriate using the appropriate corporate procedures and for a proper corporate purpose. The ATP case is a good example of that, in that the bylaw was adopted in 2006. It wasn't in any particular circumstance that could have questioned the board's purpose in doing so, and it was only enforced about a year and a half, years later when it was brought up in this case. So the court just emphasized that they would look into the actions that led up to the adoption in enforcing these kinds of bylaws. After ATP, we had a lot of companies adopting fee-shifting provisions in response to events that were being reported to the public. As you can see in this slide, of 5,000 public companies, 39 domestic companies have adopted fee-shifting provisions, and most of these were adopted by amending the bylaws rather than provisions in charters. For anybody who is interested, again, I would encourage people to look at Claudia Allen's article, which provides a really good overview of what companies are doing with regard to fee-shifting provisions. Of the 39 domestic corporations that adopted fee-shifting provisions, many of these companies are adopting them in connection with changes to the corporate structure. So in connection with a reverse stock split or a merger. Interestingly, though, you'll see in this slide that the most common circumstances in which these companies are adopting fee-shifting provisions is during ongoing litigation or in connection with a proxy contest. So it certainly appears that companies are using these provisions as a deterrent to stockholder litigation, or attempting to use them as a deterrent to stockholder litigation. So after the ATP case, we had a couple of situations in Delaware where fee-shifting bylaws were raised as an issue before the Court of Chancery. In Pignatelli versus Bylaws, that was before Vice Chancellor Noble, we had one of the first challenges to a fee-shifting bylaw after the ATP decision. Bylaws adopted its bylaw in direct response to an ongoing dispute with the company's former chairman and CEO, the plaintiff, Federico Pignatelli, who the board had ousted earlier that year. So at the same meeting that the board ousted Pignatelli, it also adopted a fee-shifting bylaw. But they adopted a bylaw that has a very interesting variant. So instead of applying it to any shareholder claimant, the Bylaws bylaw applied only to current or former directors or anyone acting at their behest who asserted unauthorized claims against the board. So it was very targeted towards this particular plaintiff. The case, however, was dismissed without prejudice, and the court did not determine the validity of such a tailored bylaw. But it would be interesting to see whether that would survive judicial scrutiny. In Cassis versus Carter, also before the Court of Chancery, but this time in front of Chancellor Bouchard, the company adopted a fee-shifting bylaw in the middle of the litigation. However, again, the court did not have the opportunity to determine the validity of the bylaw, since counsel for the company advised that they would not be enforcing and trying to apply the fee-shifting provision to that particular litigation, so they did not need the court to address its validity. Following these two cases, we have a decision that came out earlier this year in Strogo versus Hollander. In this case, a Delaware corporation approved a reverse stock split, which was essentially a going private transaction. Shortly after the stock split was effected, the board adopted a fee-shifting bylaw. A cashed-out stockholder initiated an action shortly after the reverse stock split was effected, alleging breach of fiduciary duty in connection with the reverse stock split. He was not aware of the fee-shifting bylaw at the time the action was filed, and shortly after learning about it, amended the complaint to include a challenge to the bylaw as well. So the issue before this court was whether the fee-shifting bylaw adopted after a reverse stock split applies to the cashed-out stockholders. And Chancellor Bouchard held that it does not. So changes made to the bylaws after the plaintiff was cashed out are not binding on him for the same reason that a non-party to a contract is not bound by the terms of the contract. And Section 109 doesn't authorize the adoption of bylaws to regulate the powers and rights of former stockholders whose interests have been eliminated. Despite expressing concerns about fee-shifting bylaws generally, Chancellor Bouchard did note that the motion before him focused directly with the timing of the bylaws adoption. So fee-shifting bylaws don't apply to stockholders who would no longer have an equity interest. But it would be interesting to see if the company had adopted the fee-shifting bylaw at the same exact time that it approved the reverse stock split, whether that could have led to a different result. Again, the timing here was key, that it was adopted after the reverse stock split and not at the same time. So what's the status of the law in Delaware? I would say it's really in a flux right now. Fee-shifting bylaws are facially valid, but it's evident from the cases that their application will have to be determined on a case-by-case basis. Hollander clarified that the timing of the adoption will be crucial to the application of fee-shifting bylaws, but the court has yet to actually determine the validity of any fee-shifting bylaws that were adopted in questionable circumstances. So 14 days after the ATP decision, the Delaware Corporate Law Council responded by proposing statutory amendments prohibiting fee-shifting bylaws for stock corporation. Senate Bill 236 of the 147th General Assembly proposed creation of a new section of the DGCL, which would be Section 331. This new section would prohibit any certificate of incorporation or bylaw provision of a Delaware stock corporation from imposing monetary liability or responsibility for any debts of the corporation on any stockholder. After various parties expressed concern, including some affiliated with the U.S. Chamber of Commerce, the Delaware Senate withdrew Senate Bill 236 and instead adopted Senate Joint Resolution Number 12. Senate Joint Resolution Number 12 essentially delayed any decisions by the legislature until January of this year, and encouraged any interested parties to submit input and have input on the scope of any proposed bill dealing with this issue. Senate Bill 75 was introduced earlier this year, and among other things, it prohibits a provision in the Certificate of Incorporation or bylaws that would impose liability on a stockholder for attorney's fees or expenses of the corporation or any other party in connection with intra-corporate claims. The proposed amendments do not disturb the ATP decision as far as in the context of non-stock corporations or a provision in a stockholders agreement that provides for fee shifting. And as Steve discussed earlier, it also includes Senate Bill 75 is the same bill that includes a section related to forum selection bylaws that he discussed in his earlier slides. On the same day that Senate Bill 75 was introduced, Amendment Number 1 was introduced and defeated. The proponents of Amendment Number 1 essentially sought to delete any sections prohibiting fee-shifting bylaws in their entirety from the Senate Bill 75. That was, as I mentioned, not a successful effort. So currently, the Senate bill has passed by a majority vote in the Senate, and it was introduced to the Judiciary Committee in the House on May 13th of this year. As of the date of this slide, there's been some more progress on this. So on June 3rd, it passed by the House Judiciary Committee, and it's likely to be presented to the House for a vote sometime this week. If anyone is interested, it's pretty easy to track this bill online, and I would anticipate that it will pass in the House in the near future. So there are certainly developments on this front on the horizon here in Delaware.
Hey, Vanessa, if the proposed legislation passes, is there anything that is being done to deter abusive shareholder litigation?
Yeah, so as I mentioned, I think Senate Bill 75 is a more targeted approach to addressing fee-shifting bylaws. The initial one was not as narrow as this one. So Senate Bill 75 only prohibits fee-shifting provisions in the charter or bylaws to the extent they impose liability in connection with intra-corporate claims. So that's a different limitation that we didn't have earlier on that the first proposal was significantly broader than this one is. And I think the compromise with this bill is also the forum selection clause provisions that Steve discussed, and that will deter a lot of the forum shopping that increases the expenses for companies defending against shareholder litigation.
Vanessa, Vanessa, I'm sorry. We got a question from the audience. So you showed a sample fee shifting bylaw before, and it contained a definition of claiming party that was pretty broad. Could that be read to impose fee shifting obligations on lawyers, since they obviously offer substantial assistance in claims against the company?
Yeah, so that was actually a concern raised by plaintiff's counsel in the Castis case, which I discussed earlier. As I mentioned, that case, that wasn't, the validity of the bylaw wasn't determined, since they said they weren't going to apply it to that particular action. However, in their motion to invalidate the fee-shifting bylaw, plaintiff's counsel thought, in the absence of invalidation, an order voluntarily dismissing the case or allowing counsel to withdraw for that very reason, they were prosecuting the case on a contingent basis and read the fee-shifting bylaw as broadly as we see it, and it threatened them with liability for fees and costs, since they not only offered substantial assistance, but they also had a direct financial interest in the claim, which is another definition for a related party in that particular bylaw. So it does present a concern for people who are assisting plaintiffs in these kinds of cases, or whether the attorneys could be liable. But again, that wasn't determined. The validity of that or the breadth of that wasn't determined in the Castis case. Unless there are any additional questions, which I don't see, I'll pass it on to Sarah.
Before we do that, I just wanted to comment on one thing. When Vanessa was talking about the ATP case, she mentioned that it was a certified question from the district court, the federal district court, directly to the Supreme Court. And I just wanted to flag for everybody that ATP is either the second or third case under a Delaware statute that was recently, or rather a constitutional amendment that was not long ago enacted to allow various courts and government agencies, and the first case of this type came from the SEC, to certify questions of first impression under Delaware law directly to the Delaware Supreme Court for prompt adjudication and decision. And so if any of you are facing a litigation or handling litigation in a different jurisdiction, but involves a substantial question of Delaware law on an issue of first impression that your judge or is struggling to decide or doesn't want to decide, that option is available to you to take advantage of Delaware's willingness to decide questions of first impression under its own law, under that statutory procedure. Just wanted to highlight that ATP is an example of that, in addition to a widely recognized fee-shifting case. With that, I'll turn it over to Sarah.
Thanks, Steve. I'm going to talk a little bit about the Delaware Rapid Arbitration Act, or the DRAA. Delaware enacted the DRAA in April of this year to address complaints by practitioners of inefficiencies that come up in quote-unquote traditional arbitration proceedings. A Delaware committee was formed, which was led by the Chief Justice of the Delaware Supreme Court, Leo Strine, and Chancellor Andre Bouchard, and they consulted with Delaware, New York, Washington, and foreign arbitration practitioners to better address some of the concerns of traditional arbitration. It's important to note at the outset that the DRAA is not intended to supplant existing arbitration rules. Rather, the DRAA offers parties a business dispute resolution process by which parties can quickly, confidentially, and cost-effectively resolve their disputes. I think it's also worth noting that the DRAA has some interesting history. The DRAA is not Delaware's first attempt at addressing delays and other problems of traditional arbitration proceedings. In 2009, Delaware enacted 10 Delaware Code Section 349, which I'll refer to as the 2009 Act. And the 2009 Act shared a lot of the same goals as the DRAA. Some key components of the 2009 Act were that resolution was to be completed within 90 days. There was a sitting judge on the Court of Chancery who would act as the arbitrator. The arbitration proceedings would occur in a Delaware courthouse during normal business hours. Final judgment was binding. There was a limited right of appeal, and importantly, everything was confidential. The filings, the proceedings, the docket entries, everything remained confidential. In 2012, the Delaware Coalition for Open Government challenged the 2009 Act, and the issue before the court was whether there is a right of access to the government-sponsored confidential arbitration proceedings set forth in the 2009 Act. The United States District Court for the District of Delaware found that the proceedings were essentially civil trials, and the public had a right to attend civil trials, and therefore the 2009 Act was unconstitutional. On appeal, the Third Circuit, applying the experience and logic test, determined that proceedings such as government-sponsored arbitrations are historically open to the public, and public access plays an important role in those proceedings, and therefore it found that there is a First Amendment right of access to government-sponsored arbitration. From the 2009 Act emerged the DRAA, and like I said earlier, the DRAA has similar purposes to the 2009 Act, which was to promote prompt and cost-effective dispute resolution. Basically, one of the major differences between the DRAA and the 2009 Act is we removed the government component to ensure that parties can still resolve their disputes confidentially. Delaware maintains a strong policy preference for parties' freedom of contract, and many Delaware statutes afford this maximum effect principle that you see on this slide, and the DRAA is no exception. So, for example, the DRAA allows parties to determine who should be the arbitrator, whether to utilize panels of arbitrators, the rules governing arbitration, discovery process, when and where arbitration should occur, the scope of the arbitrator's power to award final awards, and the appellate process. So essentially, the DRAA serves as a series of default provisions that parties can either adopt or contract around. Though the DRAA defers largely to the parties, parties may not invoke the Act to resolve every dispute. To qualify for use of the DRAA, there has to be a written agreement signed by the parties, which for stockholders and investors, they may not be made subject to the DRAA by a corporate bylaw, charter provision, or other similar governing documents, whereas disputes among members of an LLC may be able to employ the DRAA. The Act also requires at least one party to the agreement to be a Delaware business entity. I've put the definition of business entity up on this slide, but it's also worth noting that the Act expressly prohibits consumers' participation or invoking the DRAA. The consumer is defined as an individual who purchases or leases merchandise primarily for personal, family, or household purposes. It's also worth noting that nothing in the DRAA prevents a corporation from creating a Delaware subsidiary to enter into certain contracts and gain access to the DRAA. Finally, the arbitration must be governed by Delaware law, even if the entire underlying contract is not governed by Delaware law, and the agreement must expressly reference the Delaware Rapid Arbitration Act.
Sarah, just before you move on, you mentioned that the contract need not be governed by Delaware law. Could you just explain a little bit more what that means?
Sure. So Delaware law must apply to the arbitration agreement, but the DRAA does not require Delaware law to apply to the entire agreement or the party's other rights, remedies, liabilities, powers, and duties. So for example, if you can have a standstill agreement where disputes arising out of a disparagement clause in that agreement may be governed by New York law and enforceable in New York courts, and also have disputes arising out of a voting rights clause in the same agreement governed by Delaware law and enforceable only in arbitration under the DRAA. So the same contract can have, the entire contract does not need to be governed by Delaware law to invoke the benefits of the DRAA. This slide slide addresses some of the other things the parties must give up in proceeding with the DRAA. I don't want to spend too much time on this slide, but I do want to highlight that most of the requirements set forth in sections 5803B and 5803C are designed to streamline the arbitration process by limiting the party's ability to seek relief outside of the arbitration. The Act does this by empowering the arbitrator and implicitly the parties by allowing them to design their own procedures in the form of contract. One of the problems the DRAA seeks to address are the delays that occur in traditional arbitrations. Oftentimes, in traditional arbitrations, the parties end up in court fighting over which issues are subject to arbitration and who should be the arbitrator. DRAA resolves this delay by empowering the arbitrator and limiting the Delaware court's jurisdiction. So the parties have to concede to use the DRAA. They have to concede that the arbitrator decides all issues related to the scope of the arbitration, and they must waive the right to go to court to decide these issues. This slide details the limited jurisdiction of the Court of Chancery and the Delaware Supreme Court. The Court of Chancery is only permitted to appoint the arbitrator if the parties petition it to do so, and if the parties do petition it to do so, the Court of Chancery must appoint an arbitrator within 30 days. The Court of Chancery can also enter judgment and only enter judgment. So under the DRAA, a final award is deemed confirmed if after the 5th business day, after the final award is issued, unless there is a challenge to the Delaware Supreme Court. So before the DRAA or in traditional arbitrations, a final award, the parties must go to the court to get the final award confirmed and then entered. And this eliminates the confirmation step. The Court of Chancery, so as I mentioned, can enter judgment, enforce subpoenas, determine the arbitrator's fees, and issue an injunction in aid of arbitration, but they may only do so before the arbitrator accepts his or her appointment. Likewise, the Delaware Supreme Court only real role in this is to vacate, modify, or correct a final award in conformity with the Federal Arbitration Act. And it's worth noting that the DRAA does not permit the parties to expand the powers of the Supreme Court. Since the DRAA affords the arbitrator a significant amount of control and influence over these proceedings, I thought it was worth pointing out some of the specific provisions dealing with the arbitrator. So parties can decide who they want to be the arbitrator unless they petition the Court of Chancery to make that determination. The arbitrator may be a specific individual or an entity, and if the parties decide not to identify an individual or an entity, they at least may set forth the procedure for the selection of the arbitrator or specific qualifications for the arbitrator. And I think it's also worth noting that the arbitrator does not have to be a lawyer. This slide demonstrates the parties' flexibility in determining the arbitration procedure. So unless otherwise provided in the agreement, the arbitrator sets when the hearing will occur, where the hearing will occur, and it does not have to be in the United States, but it can be if the parties choose or if the arbitrator chooses. Each party is entitled to be heard to present evidence relevant to the arbitration and to cross-examine witnesses appearing at a hearing. And the arbitrator may make interim rulings and set the procedure for and limitations on which witnesses may be presented. And the arbitrator may administer oaths, compel attendance of witnesses, and production of documents. Again, the parties may limit the arbitrator's authority in this regard, but these are the default provisions.
Sarah, just before you move on, you mentioned throughout your presentation that the DRAA is simply a template, but that the parties can contract around many of the provisions. On this particular side, you refer to the opportunity to be heard and present witnesses. Is that something that the parties can contract out of as well? Yes,
so the DRAA recognizes, or at least the drafters of the DRAA recognize the tremendous expense and burden that traditional discovery can have on parties. And so in order to, the DRAA wants people to limit that cost and burden if they so choose, or proceed as they would normally. So it really gives the parties the flexibility to choose how they want to proceed in terms of discovery and the hearing itself. And then the DRAA does give some requirements for the final award. The final award has to be in writing, signed by the arbitrator, and the Act does not require that the arbitrator provide a reasoning for his or her final award. However, again, the parties may contract to require him or her to do that. And the final award must include a form of judgment. The final award may provide for legal or equitable relief, and the arbitrator may also issue rulings of law. And as I mentioned earlier, the final award is deemed confirmed after the 5th business day unless one of the parties appeals. And then usually I think it's contemplated that the prevailing party will then go to the court and get the court to issue an entry of judgment. If the arbitrator issues money damages only, the parties will go to the Superior Court of Delaware, and all other judgments will go to the Court of Chancery. And the procedures for doing so are set forth in the Act. One other important component of the DRAA is the time component. So obviously, as I mentioned at the outset, prompt and efficient dispute resolution is the primary goal of this legislation. And so under the Act, the arbitrator is required to issue his final award within 120 days of accepting that position, unless the parties agree otherwise. And the parties must agree to a longer term prior to the arbitrator acceptance. If the arbitrator and the parties all agree, there must be unanimous consent. The deadline, the 120-day deadline, may be extended an additional 60 days, but no more than 60 days. Finally, if the arbitrator renders his or her opinion late, there is a penalty for the arbitrator to encourage the arbitrator to make sure he or she issues his opinion timely. So as you can see here on the slide, if he is under 30 days late, there's a 25% reduction. If he's between 30 and 60 days late, there's a 75% reduction. And more than 60 days late, it's 100% fee reduction. And this provision, the penalty for the arbitrator is non-waivable, so the parties cannot contract around that penalty. And I touched on this earlier, but with appeals, the parties have 15 days to appeal the final award to the Supreme Court, and parties may contract for additional appellate review. So if after the final award the parties wanted to have another level of review, they can, in their arbitration agreement, contract for a arbitration panel or one or more arbitrators to review the final award before it goes to the Supreme Court. But that, again, is something that is left to the parties.
Sarah, just before you move on, you mentioned that the arbitrator has a certain amount of time to issue a final order. Could you just highlight again whether or not the parties can contract to extend the time period for the arbitrator to issue the final award?
Yeah, so the parties may contract around the 120-day period, but only before the arbitrator accepts his position. Once the arbitrator accepts his position, then the only extension allowed under the DRAA is a up to 60-day extension, and that's only if all of the parties consent to that extension. So in sum, the DRAA is intended to, one, provide prompt dispute resolution mechanisms for qualifying parties, and 2, honor the parties' freedom of contract. It streamlines the arbitration process by empowering the arbitrator and limiting the court's jurisdiction. One way it does this is by ensuring all disputes go to the arbitrator and not the Delaware courts, thereby eliminating the procedural and substantive distinction that causes so much litigation and delay. The Act also incentivizes the arbitrator to ensure that the parties complete the arbitration in a timely fashion, and it eliminates the back-end delays by eliminating the confirmation process of the final award. The Act also provides the parties substantial freedom of contract, as I mentioned. Who arbitrates, the scope of the arbitrator's authority, the arbitration process, and the appellate process are all up to the parties. The DRAA, as I mentioned, is largely a set of default provisions. It'll be interesting to watch whether this new Act will be successful and if the parties find it useful and what new pitfalls may arise in the arbitration process, but that all remains to be seen as this is still very new legislation in Delaware.
I think we've neared the end of our presentation. Thank you very much, Sarah. We hope you have enjoyed this presentation and that you found it helpful. If you have any questions or you want to take advantage of your 30-minute consultation, my contact information, Vanessa's contact information, and Sarah's contact information appear at the end of the booklet, or rather the PowerPoint presentation that I understand you'll receive. We thank you for joining us, and we look forward to meeting you at a future Meritas event or to working with you if you have any issues that impact Delaware. So thank you very much for your time, and I don't know if you have anything else to say, but that concludes our presentation.
Thank you, Steve. Thank you, Sarah. Vanessa, that was very nicely done. We are very lucky to have you speak to us today. Before we sign off, I just wanted to remind each of you that in the next few days I'll be sending that email that Steve mentioned. It will include the PowerPoint presentation, a recording of the webinar in the event you want to listen to it again, as well as our contact details. With that, thank you again for joining us, and thank you, Steve, Vanessa, and Sarah, and I hope you all have a great day. Bye.